Hey, it's Jack from Online Real Estate Academy and Jack Gately Real Estate. Thanks so much for joining me. Just wanted to give you our thoughts on the court hearing today with MLSPIN and what the judge said during this hearing that just took place earlier this morning. So the hearing itself was between Berkshire Hathaway effectively and the plaintiffs in the case, in the no select case. So this is the no select versus the MLS pin et al. And the big takeaway happened at the end of the hearing when the judge was talking about the Department of Justice. And I have some notes here. You can't take any audio or video of a federal court hearing, so it's only pen and paper for notes. But basically, she said at the very end, relative to the Department of Justice, that she was, quote, looking forward to their guidance and potentially their how do I want to say this, involvement in the case, using my own words there, which she said antitrust cases are very hard, and she's looking forward to their guidance. So that was very enlightening at the end of the hearing. And again, this hearing was focused basically an attempt of Berkshire Hathaway to get out of the court case altogether and to no longer be one of the defendants. So it was really Berkshire Hathaway and the attorney for the plaintiff. None of the other defendants were there because the hearing only applied to Berkshire Hathaway for today. The judge, right at the top of the hearing, was very critical of the Berkshire Hathaway corporate structure, calling it, quote, highly confusing, designed to insulate various entities effectively from responsibility. And she literally called it a, quote, corporate shell game. So that was enlightening, very harsh. I would say that the attorney for Berkshire Hathaway handled it very well. He had a very strong argument. And I thought that the attorney for the plaintiffs, no select, was not nearly as strong in their arguments overall. One of the complicating factors, and I'm not sure if this is just like a convention that the judge uses, but definitely this came up in the judge's interaction with both attorneys, is that there are so many moving parts here, especially when you have the Berkshire Hathaway corporate structure, that it was a little hard for the judge to kind of identify who's who. And there was a significant discussion about how the whole industry works relative to the salesperson and how the salesperson is affiliated with the broker, blah, 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 and how the money flows. You, as probably an agent in this business, probably understand that. But it was kind of hard for the judge to wrap her head around that. Now, that could only be because she was kind of testing the attorneys and seeing if the attorneys could explain it. It could be kind of like I call it a convention, or it could be kind of like a strategy of hers to say, I don't really understand. Can you explain it to me? Having never heard her, this is the first hearing I've ever attended in her court. Judge Patty Saris, S-A-R-I-S. And it was virtual, and you can't see anybody. It's just like a Zoom phone call. That's all it is. So you can't see the expressions on their faces, which makes it a little bit more interesting. It's just like listening to the radio, kind of. So in that case, to put a finer note on this, the big question that the judge had, and again, I'm not a lawyer, way too smart to go to law school, was whether or not there was an express agreement to have a conspiracy. And I think both sides have stipulated that there was not an express agreement to have an conspiracy. That, as the judge, I don't want to misquote her here, that nobody got around, a table with a beer or a cup of coffee and said, okay, we're going to conspire. It wasn't that obvious. Effectively, the plaintiff's argument was that the business model of the industry writ large, supported by the NAR rules, and NAR is not technically a member of this lawsuit, but MLSPIN has rules that are very similar, but specifically by NAR's rules and also Berkshire Hathaway training manuals, that the business model was, in effect, a conspiratorial business model. And if I have the terminology here right, that for a antitrust case to be successful, there does not necessarily have to be an express agreement of conspiracy, but there could be a tacit agreement of conspiracy. One of the aspects of a tacit agreement would be what they called parallel conduct. And again, not a lawyer, and you don't want to, quiz me on the 9 elements of an antitrust conspiracy or however elements, because I would fail. Just trying to recall by memory of listening to this hearing, one of the elements of a tacit conspiracy is what they call parallel conduct. And apparently, it's not a sufficient, but it is a required aspect of it. And there was a significant focus on this hearing of whether or not there was parallel conduct. So it's not like everyone, overtly decided to do something, but they all did something, right? So it's not like they huddled up and said, yeah, we're going to do this, but basically everyone did it anyways. It's kind of like an unspoken conspiracy, if I could just kind of translate it into plain words. And so the judge at the end decided to take this under advisement. I think the next big shoe to drop on this will definitely be the potential Department of Justice involvement, not only in this case, but also in the Kansas City case, the Stitzer-Burnett case, which was mentioned at this hearing today on several occasions. She did bring up the bombshell video. You remember the bombshell video that Mr. Ketchmark showed during the Kansas City trial, where they brought out Mr. Dalton, formerly of Berkshire Hathaway, and he, how do I want to say this? He had some crude comments about cutting the commission. You might want to remember that. That's also the video that was on the Tom Ferry podcast, which Tom Ferry subsequently deleted from his channel with no further explanation, but was then posted by an anonymous account on YouTube. So there was discussion about that, and she thought that if the judge was characterizing that video, which she was offended by clearly, as he should have probably been disciplined, and then she questioned whether or not that came out before or after the Me Too movement. She was pretty critical of that. I'm just checking my notes. Now, anyways, she was astounded by the video. Let's just put it that way. Although that was not a central aspect of today's hearing. The bigger question was, is the business model a tacit conspiracy? I think that's the biggest takeaway from today's hearing about the MLSPIN no select court case in the Berkshire Hathaway's effort to get out from under the case effectively. All right, so I'm Jack from Jack Gately Real Estate and the Online Real Estate Academy. Thank you so much for watching. We'll keep you posted. Have a great day. Go make some money. Bye-bye.